Greetings, listener nuggets. What we're going to do today is we're going to discuss some more very misleading posts by a nugget on Facebook by the name of Denny Jovica, whatever you want to call him. Now, I prefer to call him Chief Walking Eagle, which is a name that the American Indians give to people who are so full of shit that the eagle can't fly, which is always a walking eagle. We're dealing with a guy here he's parading around the place on all of the law groups as if he's a high court judge and he's a first-year law student. So bear that in mind when you're reading his post, when he gets all arrogant with you saying that I'm listening to this lecture, I'm listening to that lecture. Now, the post in particular that I'm going to be dealing with is important because he obviously hasn't done administrative law or he didn't understand it. I did and I did. Now, I've got some screenshots which you'll be able to see in the video once I finish making it because I'm recording the audio at the moment. And this is out of Get Out of Paying Fines, Rego Fees, Tolls and Rates on the 19th of October. And he said, did you know, Mr. Upset Citizen, that if you are unhappy with a state law or the actions of a public servant, and if you feel that the law either violates your implied rights to due process or is inconsistent with institutional integrity and independence or repugnant to the cable doctrine, or, and I don't know why that or is there, then you can take action against the Commonwealth official with a writ that has original jurisdiction in the High Court. Your Constitution protects its citizens. And then we've got a link to Section 75, and it continues on to say, in which a writ of mandamus or prohibition or an injunction is sought against an officer of the Commonwealth, the High Court shall have original jurisdiction. So then he says, what is a writ of mandamus or prohibition? I'm glad you asked. A writ of prohibition is if you want to stop the government doing something. Wrong. A writ of certiorari, basically a restraining order preventing further action pending review, sort of like an AVO against the government. Wrong. Mandamus is to compel the government to do something which they should be doing but are not. That one's almost correct. Not to worry that he's missed a few of these out, but we'll get past the post and we'll discuss this area of administrative law. The case of you versus the government goes directly into the High Court as the court of original jurisdiction to hear such matters. I don't know that he actually comprehends what original jurisdiction means, and I'll cover that in a second as well. Just remember, kids, you need to prove in the High Court that the government is wrong in the above areas. Do your research well, and you just may find yourself in the High Court. And if I am not mistaken, a cause of action against a Commonwealth official is saved for costs, so you don't have to pay costs if you lose, but have a good crack at it. Well, that's not always true either, but we'll go back to the beginning of this nuggetry. And Section 75, subsection 5, is a very interesting section. But what we have to understand first, people, is that Australia uses the common law system of law. So normally, unless a statute specifically excludes something, it is taken to include it. Okay, so where it says 75, original jurisdiction of the High Court, and I'll read the whole section 75. In all matters, 1, arising under any treaty, 2, affecting consuls or other representatives of other countries, 3, in which a Commonwealth or a person suing or being sued on behalf of the Commonwealth is a party, 4, between states or residents of different states or between a state and a resident of another state, 5, in which a writ of mandamus or prohibition or an injunction is sought against an officer of the Commonwealth, the High Court shall have original jurisdiction. Now, when I did this section in administrative law, my lecturer pointed out, it says a writ of mandamus or prohibition or an injunction. Well, you must understand there are two types of remedies discussed here. One is a common law writ, and one is an equity remedy. But in the common law remedies, mandamus and prohibition, It does not exclude the others. So in that area, you have mandamus, prohibition, certiorari, habeas corpus, and quo warranto. In the equity remedies, you'll have injunction, order of specific performance, lien, and declaration. Those are all there because of Section 75, subsection 5. What does original jurisdiction mean? Well, original jurisdiction of any court is where the action begins, as opposed to the other side of the court, which is the appellate jurisdiction, is where you appeal to. And all of the courts will have both sides except for your magistrate's court, because in most cases you can't appeal to a magistrate's court because that's the cellar. That's the lowest there is. You can't go any lower than the cellar, you know. So that's what original jurisdiction means. And he says that we've got, let's see, I'm not sure why he's talking about the cable doctrine, because from my understanding of that decision, there's quite a few things in it, but the cable doctrine was, from my recollection, that where a court can be invested with federal jurisdiction, and that's usually under the cross-vesting acts, where a court can sit as a federal court. So, for example, when I was back in Western Australia, I've been in the magistrate, well, actually I've been in the old Court of Petty Sessions, sitting as a federal magistrate's court, and it's now the Magistrates Court of WA. I've been in the District Court sitting as the federal court. Never been in the Supreme Court sitting as a federal court. And so any court that is can be cross-vested with federal jurisdiction has to have certain attributes to it. And in the cable decision, this came up, and the decision discussed how before the formation of the Commonwealth and the referenda, the people from the colonies and the people who were going to be the Commonwealth, they all agreed that for the Commonwealth to allow the states to have federal jurisdiction, those the state courts had to be of a particular type, and they had to have certain attributes matching Chapter 3 of the Commonwealth Constitution Act courts. Now, not a lot of them are like that these days, and this is what the cable decision was. So I'm not sure why he mentioned that. He might have a valid reason, I don't know. A lot of the time, it's hard to figure out what he's on about, because Chief Walking Eagle is not that, he's not that well written. Sometimes he's right about things. He did a constitutional post about Section 80 of the Commonwealth, and, you know, when you're charged upon indictment against a crime, and it's a Commonwealth crime, you get trial by jury. He was right about that, even though people wanted to shoot at him. So it's a case of we need to now look at these various different writs. And I'm looking at his posts here, even though he's got me on block because he couldn't handle me pulling him up. He likes to showboat. He likes to show you guys that he knows more than you do, which is where you'll get things like in this post where he says, just remember, kids. Well, I don't think you guys are kids. You might not know about law, but that doesn't mean that you're kids. I mean, some of you will know more about mechanics than he does. Some will know more about roof carpentry. Some of you know about this. So I don't think you're kids. I just think you don't know as much about law as maybe he thinks he does. Of course, the greatest impediment to learning is what we think we know already. But don't worry about that either. So, what is a writ of mandamus or prohibition? Notice that he's only covering those two. I'm going to cover the others too. A writ of prohibition is if you want to stop the government doing something. Well, yes it is and no it's not, because it's only part of the government, because prohibition is something that you serve from a higher court on a lower court or judicial body to prevent them going ahead with a hearing. You can't just issue prohibition from, say, the Supreme Court of Victoria onto the police department. If you tried that, I'm telling you now, though, not only will they laugh at you, And if they rang me up and tell me to come down at the hearing, I'd sit and laugh at you as well, because you're obviously a nugget. If you were really, really lucky to get that through the court's registry and this went to a chambers hearing, it would be thrown out because it's vexatious, abusive process. Boom, you're gone. Now, he mentioned cost orders later, and we'll talk about that, but you'd have a cost order put on you to punish you for being a nugget, unless you're on a pension or something. Anyway, so prohibition generally works where, for whatever reason, you don't want a lower court or tribunal to hear a matter, and you would usually combine it with the other one that he mentions next, certiorari. And I've used these without even leaving the lounge room. I had a friend in Dublin told me about his sister. She's divorced. She's remarried. She's got a daughter. And her and the husband, I don't know why any good Irishman would do this, but they got jobs in England, and they're moving to England so that they can live and work in England. So the father of the little girl decided that he wanted to have 50-50 custody with the mother. And of course, that's a big threat, because how the hell are you going to have 50-50 custody when they're over the Irish Sea in England? And so it's gone to the court. The father had been caught filming the little girl getting undressed and showering. I think she was about 7 at that stage or something similar. And so my friend Vin said to me, "What do we do?" And I said, "Well, this is what you do. You go to the High Court of Ireland site and download the documentation, because a lot of these courts will have a document that you can download that you generally fill in, because it's a case of it's not like a magistrate's court document where you just write in the boxes. When you get to district court, county court level, depending on which state you're in, you draft the documents from scratch, and you don't just fill the boxes in. So I said to him, download these, and what we'll do is we'll look at it. So what he did was, while we're talking on Skype, we went to High Court site. He downloaded writ of certiorari and a writ of prohibition. So I explained to him that what it would do is, the High Court, if they issued them, certiorari will quash any result in the Family Court of Ireland and remove that case to the High Court, and the prohibition will prevent them from moving. They cannot hear it any further. So he was pretty happy with my explanation of it. So he went around to his sister's, and her barrister was there. And I'd said to him, "Has this about the little girl been brought up in the court?" And he said, "Yes, it has." So I asked him, "Well, what did the judge say?" Well, he didn't seem pretty concerned. And I'm like, okay. He's not concerned about a little girl who's actually being filmed by her old man. He's obviously in the pre-stages of abusing her. And apparently not. And I said, "I think you've got very strong grounds, because he's not taking into account relevant considerations in his decision." And that's something you guys can Google. I don't want to go into undoing a decision in administrative law. You can Google that, not taking into account relevant considerations. So he grabbed these 2 blank forms, and they have it on the top, writ of certiorari, writ of prohibition, and he went around to her place, and the barrister's there. So he told his sister what I told him. The barrister said to him, "Can I have those?" Vin thought, "Oh, well, sure." So he gave them to him. Now, what he didn't know was the barrister had a plan. So the barrister went to the court, somehow managed to have a word with the judge on the sly, and said, "Check this out. This is what's going to happen tomorrow." The judge changed his attitude totally, and apparently gave sole custody to Mama, and the father's allowed a visitor. I can't remember if he said once a fortnight or once a month, for a couple of hours in England, with a social worker present. So these remedies will work if you know what they're doing. That's not exactly how you're meant to use it, but that's actually just trying to show you guys I've used it in an unorthodox manner, but that's what they're meant to do. So certiorari is not a restraining order at all. It is only on a judicial body. It could be from the Supreme Court onto VCAT. Normally, the reason you would do it is because the hearing is out of jurisdiction and they shouldn't be hearing the matter, or it's being conducted in such a manner that, you know, there's not a perceived bias, but there's actual bias, and that will cause you a lot of trouble. I don't know how often that you'd use it, but not to worry. Mandamus is an interesting Latin word, and it means I command, and it's from the Queen, you know. I don't know if it's from the fictitious Queen of Australia that doesn't exist, or we won't go there. But anyway, mandamus compels the government to do something which they should be doing, but they're not. That's pretty much correct. And what mandamus is meant to be is where you have a situation where a public servant, a member of the executive, is not doing something that they are obligated to do as part of their duty, and it's causing you a damage. And you have to be able to show the court that they have been told they've got to do it and they're refusing to, or it could be, the refusal can be ignorance. Like, you know, you write a letter to the guy and say, listen, I want you to do this, and you're not doing it, and they just don't respond. That can be a refusal as well. So it says the case of you versus the government goes directly into the High Court. Well, it does. I'm not entirely sure why he says in the first post, if you're unhappy with a state law, because this is the entirely wrong jurisdiction. If it's a state situation, you should be going to the Supreme Court of your state, and just be aware that not all of the state Supreme Courts have these writs anymore, because, for example, in Queensland, under the Judicial Review Act, I think it is, they have an order in the manner of mandamus, an order in the manner of certiorari. So it's sort of like these Holden Commodores you see floating around with a Chevy badge on it. Well, it is, but it isn't, you know. So if it's state, you've got to go to the Supreme Court. You're not going to get into the original jurisdiction of the High Court because they're not officers of the Commonwealth. You know, I don't know why he put that. So it will have to be you versus the Commonwealth into the original jurisdiction, and you're going to have to prove that you've got standing to bring this action. And standing in the actual legal term is locus standi, which you're going to, like, for example, mandamus, you're going to have to prove that the public servant owes you a duty. They're refusing to perform that duty, and that you've been damaged by his lack of action. So it could be something like, say, for example, Vic Roads is refusing to transfer a registration of a vehicle that you've purchased from the guy that you purchased it from to you for some stupid reason, and it's causing you a problem because you can't insure the car and you're driving the thing around. And so, well, actually, no, hang on. I just said we can't go with state, and I've gone and done it with state. So we'll stick with Commonwealth. Who could we bang in the Commonwealth? Who don't I like? Oh, I know, Veterans Affairs. I don't fucking like the Veterans Affairs. That's who we'll bang on. I could go down to the Veterans Affairs Department, and I could apply for a white card, which I am actually eligible for, and they refuse to process my application. Now, they owe me a duty to process the application so that they can figure out where I stand. Am I eligible or am I not? And they are obligated to do that, and I don't know what the time limit would be, but it's certainly not going to be, you know, I lodge it today and they can take 90 days before they even start processing it. They have to do something with it pretty much ASAP. Then you could go. I'm not entirely sure that going to the High Court originally would be the best way, because they might say that you should go through the make a complaint to the guy's supervisor or whatever. Personally, I don't know. I would be more of a inclined to hammer them so that they don't mess with you again. So that's what it is. You've got to be able to prove they owe you a duty, they're not doing it, that's causing you damage, and then you'll have locus standi. And standing is extremely important. Some of you guys might be aware of the case of Stefan Kozborski versus the state of Queensland in 2013, where a member of the Hells Angels was used for a special case to try and get rid of the Vicious Lawless Anti-Disestablishment Act, VLAD, which was against the outlaw motorcycle clubs. There was a lot of argument, and we all waited for months, and they came back and said he didn't have standing because he hadn't been charged with an offence under VLAD. In fact, he hadn't been charged with anything. So they said, no, you don't have standing to challenge it, and they threw it out on that technicality. So the government didn't win, and Kozborski didn't lose. They threw it out on a technicality, which unfortunately is the way the system works. So let's have a look here, because I've actually got the High Court rules handy here. So I'm just going to look up mandamus here. I'm going to read you some more rubbish in a minute. So, it's quite interesting when you actually read the details of all of this stuff. And a lot of them are discretionary. So, for example, when you go in for equity remedy of, what do I call it again? Declaration. In a lot of cases, it might be called declaratory relief. Well, that's discretionary, and that means that the judge does not have to give it to you. Now, some of these are discretionary. Let's have a look here. Like, for example, here in the High Court rules, it says certiorari, a discretionary remedy. The grant of a writ of certiorari will be at the discretion of the court, and a number of different factors will be considered by the court in the exercise of the discretion. I'm not going to go through all of it because it's quite detailed. Because when you start reading the grounds for it, it's not as simple as a couple of paragraph post from Chief Walking-Eagle on the internet. But I'm looking for the mandamus guy. Oh, here it is. All right, mandamus. Okay, definition. The writ of mandamus commands any person, corporation, or inferior tribunal or court invested with a public duty to perform that duty. Then it mentions a few cases here and there. The writ will issue in all cases where there is a specific legal right and no specific legal remedy to enforce that right. The only intrinsic condition on the issue of the writ is that a public duty be owed. Mandamus has never been limited to persons or bodies who have a duty to act judicially, and included in the ambit of the writ are executive and ministerial processes. Now, when it says ministerial processes, be aware that in the Westminster system, Parliament is supreme over the courts and the executive. So you can't issue mandamus on Parliament, much like one of the other Chief Walking-Eagles, Wayne Glue, tried to do. You cannot go and put mandamus on Parliament. Members of Parliament, possible, but that one's a 50-50 deal because Parliament's supreme over the courts. So let's, where do I get up to here? The court will not, however, strain the law to find that a public duty exists. The court only needs to consider if the duty has been performed. There is no need to inquire into if, in the performance of that duty, the correct decision was reached on the facts of the matter, because that would then take them into the realms of a merits review, and theoretically they're not allowed to do merits reviews of ministers, like for example the Minister for Immigration cancelling your visa, whether it's a good decision or a bad decision, supposedly is outside the ambit of a judge. And I say supposedly because the federal judiciary have been expanding their powers over a period of time, and they actually are doing merits reviews, but they're just saying that they're not when they are. Where the hell did I get up to here? However, the writ is not limited to simple cases of refusal to exercise jurisdiction. If an authority has not exercised its duty and the time for such exercise has expired, or if the authority claims to have exercised its duty but is shown to have misconstrued it, then mandamus will lie. So you do have a cause of action there. See also the annotations to Section 33 of the Judiciary Act 1903 and 75.5 of the Constitution. So it says here the High Court has two statutory bases of authority to grant mandamus. And it's what we just had a look at. Judiciary Act, I just mentioned Judiciary Act 1903 expressly grants the High Court power to issue writs of mandamus, and of course the Constitution 75.5. Furthermore, once some other head of High Court jurisdiction is established, the Court may grant the writ in the exercise of judicial power of the Commonwealth embodied in Section 71 of the Constitution, and of the power completely and finally to determine any cause or matter pending before it, conferred by Section 32 of the Judiciary Act. So where it says any other head of High Court jurisdiction, so if you went in to the original jurisdiction or the appellate jurisdiction for some other reason, mandamus, for want of a better way of putting it, could be tacked on to the back of it. So, for example, if you were going in there for a declaration that this law is invalid, you could put a mandamus on the back, but that goes for all of the common law remedies. If you're going to tack them on the back of the declaration, you can tack some of the equity ones on. I mean, there's no reason, I can't see why you wouldn't be able to exercise a declaration, a lien, and say, for example, mandamus, all at the same time, depending on the case. So don't take that as a general rule, people. One thing you'll learn with law, there's no general rules as such, and that's another thing I've seen Chief Walker-Eagle doing, making specific rules as a generalisation, and he put some bloody case up, and I can't see them and read them out to you because he put me on block, because I called him out to a public debate which he wouldn't have a bar of, and he was an admin in this group, so he booted me out of the group and deleted my challenge, but, you know, enough people saw it that we all know that he's full of shit. Anyway, he put this up about if the states can't legislate for something if the Commonwealth chooses not to. And I thought, what the fuck are you on about? We're going back to Section 51 of the Constitution, and Section 51 is another thing that a lot of people don't get the hang of, because it contains three heads of power. It's got exclusive powers of the Commonwealth, residual powers of the state, and concurrent powers which can be exercised by both. And I thought, well, what are you on about? That's not true. What it turned out was he was showboating again, and he'd just read some, or he hadn't read it, he was listening to his lecture, and he hadn't got the hang of it again, and he'd gone off half-cocked, and it was about same-sex marriage. Now, I didn't get that out of him until later, when he said about marriage, and I said, oh, that's an exclusive power of the Commonwealth. No, it's not. No, it's not. Well, you guys go and look in 51 for yourself. You'll find that marriage is an exclusive power of the Commonwealth. And, you know, he was waffling on about stuff, and the reason that the states couldn't legislate in this matter, it was an exclusive power of the Commonwealth, because the ACT passed a Marriage Equality Act or some bullshit. I forget what they called it, and they were going to recognise gay marriage. Unfortunately, the ACT doesn't have the power to do that. It's not even a state. Australian Capital Territory is shorthand for Australian Capital Territory of the Commonwealth of Australia. Same as Northern Territory is a Northern Territory of the Commonwealth. So they've got an even lower standing than a state. So he doesn't get a lot of these things. And, you know, the Section 51 powers, some of it can be very, very complex. And Section 109 and Section 51 is meant to work in conjunction. You're meant to use those together. So the Section 109 is another one that's not a general rule, where a law of the state and a law of the Commonwealth, if they conflict, the law of the Commonwealth will take precedence. That's only if it's an exclusive power of the Commonwealth, or if it's a concurrent power, the states have agreed the Commonwealth exercise it. Otherwise, the state has the rules. The state will overcome the Commonwealth if it's a residual power of the Commonwealth. Reckon we're going to end up doing a whole class on administrative law. It's going to be 8 hours long in a minute. Anyway, what bullshit was I up to? Okay, yeah, we're talking about this other head of Commonwealth jurisdiction. Okay, so an applicant for a writ of mandamus in the High Court need only show that the applicant has requested performance of the duty. This will get some of your attention because I'll mention the case they're talking here. It's RV Bristol and Exeter Railroad Company and 1843 4QB 162. Right, now RV Bristol and Exeter Railway Company means, what year is this? 1843. So the Regina, not Rex. So that was the Queen versus Bristol and Exeter Railroad Company. So it's a criminal prosecution for some reason. 4QB 162. Well, that's the Queen's Bench. Remember, you guys are always wanting to flip all the courts to the Queen's Bench? That's a Queen's Bench case. The next ground is the performance was refused or neglected. And where the writ is sought pursuant to 75.5 of the Constitution, the authority requested to act was an officer of the Commonwealth as provided by that section. So if he's an officer of the state, that's going to be really, really dodgy. And in one of the other things I was reading earlier, it said about if it's any of these are sought against an officer of the state who can sit in federal jurisdiction, like a Supreme Court judge, county court judge, magistrate, it's not even clear cut whether you can do that. So I don't know what the answer to that is. Might be a case of suck it and see, I don't know. Grounds for the issue of mandamus. The usual basis on which a writ of mandamus will issue is to control the exercise of statutory discretionary powers. Generally, mandamus can be obtained to 1. Compel a tribunal to issue a licence where there is no discretion to refuse. 2. Requiring the stating of a case for the opinion of a superior court. That's an interesting one. So if the inferior court is neglecting to give the reasons for a decision or ratio decidendi in a case and you need to appeal, you can mandamus them. 3. For production of public documents. It will not issue, however, to command general permission be given to inspect all the documents in the possession of a party. 4. To compel the implementation of binding tribunal decisions. Well, that's interesting. So if a tribunal makes a decision, you can get mandamus to enforce it. And of course, the tribunals generally can't issue these writs. 5. To ensure that a court or tribunal exercises its jurisdiction. Mandamus will not lie, however, when the error is within jurisdiction. The court only needs to consider if the duty has been performed. There is no need to inquire if, in the performance of that duty, the correct decision was reached on the facts of the matter. See, you're not allowed to go into a merits review again. And 6. To restore a party to an office from which the party has been wrongly dispossessed, provided that the office is of a public nature. It will also issue to admit to such an office a person who has the right to it but who has never had possession. It will only be granted in these circumstances if the office claimed is vacant at the time of the application. See also the annotations in relation to quo warranto. Oh, I'm not going to read you about that. Then it goes on about the limitations to the issue of mandamus. I will read this little bit here. Locus standi. Mandamus will only issue on the application of a party who is owed a specific legal right to the performance of the duty in question. And this is from RV, Guardian of the Lewisham Union, 1 Queen's Bench, 498, 1897. And it mentions other cases here as well. New South Wales, Victoria, Commonwealth, all sorts of stuff. This right must accrue to the applicant over and above any rights the applicant may have as a member of the public or of a group or class who stand to benefit from the exercise of the duty. So it's got to be a duty owed to you for whatever reason. The mere fact that an applicant is part of such a class, all of whom are equally interested in the performance of the duty, will not give the applicant standing before the court to obtain the writ. That's mainly from English cases. In fact, here's ex-party Cook, 1970, RV Customs and Excise Commissioners, RV Clear, which is 1825. While this law has been interpreted narrowly to apply only with regard to a specifically enforceable legal right, in more recent cases the courts have issued mandamus to applicants who have no more than a substantial personal interest in the exercise of the duty in question. In RV Whiteway, ex parte Stevenson, 1961, VR 168, it was held that the right could be something less than a legal enforceable right, provided it was held over and above other members of the public. For the purposes of locus standi, an applicant will be considered to have a legal right to the performance of the duty if the applicant shows a substantial personal interest in the performance of the duty. Let's see. However, this widening approach has not yet gone so far as to allow any member of the public to challenge public officials on the grounds of public interest. Oh, okay, look at this one. RV Metropolitan Police Commissioner ex parte Blackburn, 1968, 2 Queen's Bench, 118. Now that Blackburn, I've read a few of his cases before where he's gone in front of Lord Denning in the High Court of England, which this isn't, this is Queen's Bench. And Blackburn is someone who tried to prevent the British government from entering, as it was then, the EEC, the European Economic Community. And I can't remember what it was he wanted. He might have wanted an injunction or something similar. And of course, you can't get an injunction from the Court on Parliament. And Denning, I specifically remember it was a classic. He said, yes, here's Mr. Blackburn, ever vigilant in protection of the law. And you see, some of the judges like to see people who give a shit and want to stand up for things. The unfortunate thing was he couldn't give him a remedy, and I had a similar situation with a habeas corpus I did in Queensland. The judge told me he couldn't give me habeas corpus because no bail application had been made and refused, which was my screw up because I assumed my friend had made that. I didn't ask him. But then he held a hearing anyway because of some of the other stuff that I alleged in the affidavit. And so the judges will act honourably if they see someone's trying to do something which in their opinion is honourable. Now I've got to find this fucking Blackburn guy again. And in that one case, this is interesting too. I use this on the bottom of my documentation. Denning quoted someone from hundreds of years before, and I can't remember who the hell it was. It could have been Cook or someone like that. It's spelt C-O-K-E, Coke, but it's Cook. And it says, "Be you never so high, the law is always above you." And I always put that on. That was from a 1977 case, and I always put that onto bottom of my documents when I'm messing with the government, just to let them know you're not above the law. In Sinclair versus Maryborough Mining Warden, 1975, 132 CLR 473. Actually, I'll tell you what that means. 132 CLR 473 means it's a Commonwealth Law Report. You go to volume 132 and look at page 473, and you'll find it. Anyway, and it also says 5 ALR 513, and it's the same thing except instead of Commonwealth Law Reports, it's Australian Law Reports. So you look at volume 5, look at page 513, and you'll find it. So in this case, they said a public interest objector to the mining of Fraser Island was granted mandamus to force the Maryborough Mining Warden to conduct hearings evaluating applications for a mining lease according to law. While members of the High Court referred to the undoubted matters of public interest, the decision in relation to standing was not reached on these grounds, rather on the basis that the appellant had, as an objector in the proceedings, a right to enforce the proper conduct of the lease hearing. I like that. Some nosy bastard fucking with the mining companies. That's got to be a good thing. Fascist bastards. And then it mentions, the reason I'm pausing here is because I'm trying to not read out all of these case things and get to the next part of the text. Where Sinclair above was distinguished on these grounds and mandamus was refused. Okay, so that sounds out of context. Oh, okay, because in these other cases it was refused and then Sinclair is different to the other cases. This is also discretionary. Mandamus is not a writ as of right and will not be issued as of course. So in other words, as of course just means just because you apply for it, they're not going to go, oh, that's it, yes, not a problem, here you go. Have a fucking writ of mandamus. Do you want fries with that? Doesn't work like that. It's discretionary. A lot of these things are discretionary to prevent abuses and all sorts of nuggetry that could happen from, you know, people going in there and getting writs and injunctions and all sorts of shit when they shouldn't have it. Where are we up to now? Once it is established that a duty exists and has been refused performance, the writ will generally be issued. The court will exercise its discretion and refuse to grant mandamus only where there is an alternate and equally why do they have to use these fucking big words? Efficacious remedy, or where on the facts it would be just to withhold it. So if there's another remedy, or it doesn't suit justice and it's a 50-50 where justice is not defeated by it being issued and it's not defeated by not being issued, they won't give it to you. In deciding whether to refuse issue of the writ, the court will take a liberal interpretation of the facts in order to ensure that no injustice is done by the refusal. The court may exercise its discretion and refuse the writ where, holy shit, look at all this. One, there's a delay by the applicant. Mere delay in applying for mandamus will not in itself affect the issue of the writ, but mandamus may be refused if the delay was unreasonable in all the circumstances of the case. This is why I've said to people on Facebook, you guys have got to quit this reading everything black and white and read shades of grey, because as this says, it may be refused if the delay was unreasonable in all the circumstances, because they'll get the general rule and look into it to make it specific and see whether you've got some grounds. I mean, you might have not applied for the writ of mandamus for 6 months. Normally that's unreasonable, but you got shot and you've been in hospital. Then they'll say, oh, okay, well, that's not unreasonable, and you'll get granted. And law is many, many, many shades of grey. It's very rare that it's clear cut and it's black and white. 2, the application is not made in good faith. See, now that's where you get back to the courts have the ability to dispose of anything in their jurisdiction that is vexatious, frivolous, abuse of process, or it does not have a cause of action. So if it's not in good faith, it has to be vexatious. Mandamus will be refused if the respondent can show there is some improper motive on the part of the respondent. Now, for example, where the real aim of the application is to put a competitor out of business. The writ may also be denied on grounds of bad faith, where the application has been made on the behalf of some other person, or for the achievement of an unlawful purpose, including an attempt to circumvent the laws of a foreign country relating to personal status. Fuck, that sounds interesting. I wonder what that shit's about. R.V. Brentwood, Superintendent, Registrar of Marriages, ex parte Arias, 1968, 2 Queen's Bench, 956. Yeah. Somebody must have gone to the UK to get married and they couldn't get married in their own country or something. Don't know. In exercising its discretion, the court will consider the general conduct of the applicant. Yeah, which is fair enough. That sort of sounds like the New Testament where Jesus Christ said, by their fruits so shall you know them. Not that I'm religious, but you can get all sorts of things out of religious books as well. Number 3, the grant of mandamus would be futile. The court will not grant mandamus where the respondent authority has no power to do the ordered act, or where the result would ultimately be the same. Mandamus will also be refused where compliance with the writ could only be made by the performance of an illegal act. And number 4, the decision under review was made by consent. See, well, generally online people say consent means everything, which is not always true, because in a common law system, you are restrained by law from consenting into anything that would diminish your rights or which is unlawful. So, for example, a woman can't consent to be raped. It's not possible at law. Some things you can consent to, and in this case, the decision under review was made by consent. So, if you're taken to consent to it, they're not going to allow you to then mandamus it. It says R.V. Ross Jones, ex parte Beaumont, where the family court judge whose decision was challenged made the ruling on his jurisdiction at the behest and with the agreement of both parties. Then it says here where there's an alternative remedy, the mere existence of an alternative remedy will not of itself prevent the issue of mandamus. The alternative remedy must be equally convenient, beneficial, and effective in order for mandamus to be refused. A right of appeal will generally be considered as an equally convenient alternative. It's this Beaumont case again, which involved an application for mandamus pursuant to Section 75(5) of the Constitution, but note Henderson v. Pioneer Homes Proprietary Limited, where it was held by a majority in the High Court that mandamus was, in the circumstances of that case, the more satisfactory remedy. The fact that the appeal is out of time and would require special leave of the appeal court in order to proceed will not affect the convenience of the appeal as an alternative remedy, and mandamus will still be refused. What they mean is that generally you've got time limits on appeals and that sort of thing. So say, for example, you've got the appeal by right for 28 days. On day 29 that is gone, and you now have to seek leave to appeal. That can be done at any time. I mean, there was a case where a guy in South Australia brought a case to the High Court. He had and had gone through the system, and he had to seek leave. It was 30 years after his accident on South Australian Railways, and he won. So time limits do not cut off if there's a valid reason, like we saw before, where we're talking about the time delay for applying to mandamus. If you've got a valid reason, the court will allow you to come in out of time. So don't stress where people say 28 days are up and you're on a one-way ticket to Cactus City. You might be on a one-way ticket to Cactus City, but you don't have to be. You will be if you're listening to Chief Walking Eagle, though. Where are we? Okay, so I'm trying to figure out whether to read this or not because it's all case stuff. C.R.E. reference Keeley ex parte Nuckman Proprietary Limited, where Gibbs C.J. held that the appropriate remedy was not mandamus but an appeal to the full court of the Federal Court of Australia under Section 24 of the Federal Court of Australia Act 1976. That such an application was out of time and could therefore only be made by leave was nothing to the point. However, the court will not be persuaded to refuse mandamus where the alternative method by which the applicant may receive a remedy is a series of private prosecutions. It's back to that Blackburn case we had a look at. Mandamus will not lie against the Crown. Well, this one's an interesting one. I will read this because this is important. A writ of mandamus cannot lie to compel the Crown. See R.V. Powell, 1841, 1 Queen's Bench, 351, Act 361, where Lord Denman, C.J., explained that this arose from the incongruity of the sovereign ordering herself to do an act. Now, you've got to remember, in these courts, they're not the people's courts. Anyone that tells you, oh, they're the people's courts, punch them in the mouth and say hello from me, because these are Her Majesty's courts. Right? If you're in Australia and you're in one of the states or territories, you're in a penal colony. Australia's not a sovereign country. and you're in a penal colony, it still all is under the Crown. You cannot order the sovereign to do something when, go and have a look at a writ of mandamus, and it's basically the Queen ordering the Queen to do something. It's just a legal oxymoron. The distinction is illustrated by. Oh, hang on, I've jumped a paragraph. Hang on. Equally, the writ cannot compel those acting as the servants or agents of the Crown. See R.V. Commissioners of Inland Revenue, R.E. Nathan, 1884, 12 Queen's Bench, 461 at 478 per Bowen L.J., where no writ issued against the respondents, as they were found not to be acting or refusing to act in their own right, but merely as agents and servants on behalf of the Crown. Now, that one is very, very dodgy because technically the police are not public servants, they're officers of the Crown. So where it says here that they're servants or agents of the Crown, you can issue mandamus on the police, and I think I've got, oh no, this is High Court one. I've got the WA one somewhere, the notes, but I don't know, I don't have it to hand. They have issued mandamus on the police in Western Australia, so they are officers of the Crown. So things are not clear cut on that one as well. However, mandamus will not be refused if the duty is owed individually to the respondent in his or her own right. This distinction is illustrated by R.V. Commissioners for Special Purposes of the Income Tax, 1888, 21 Queen's Bench, 313, where the right at issue was a right to the repayment of taxation money which was paid to the Crown through the Commissioners of Income Tax. There, Lindley L.J. stated that the application before him was, quote, not to enforce the payment of money by the Crown, but to enforce the making of an order by the Commissioners, which it is the duty of the Commissioners to make, and without which the repayment cannot be entitled, end quote. You notice the difference? It's not to enforce the payment, it's to enforce the Commissioners to make the order, which without that the payment can't be made. Therefore, while no mandamus can attach directly to the Crown, i.e. via the Commissioners in their capacity, the writ can and will attach to and issue against the Commissioners in the exercise of their duties as owed individually to the affected applicants. That must be what they did to the cops in WA. Just read this, see if we want to talk about this shit. Nah, leave that alone. Mandamus and declaratory orders. Originally in circumstances where mandamus issued, no declaratory relief could be ordered. Remember I talked to you about declarations? Oh, actually, I didn't even describe that shit yet, did I? I didn't do any of the equity remedies. Well, I'll do the declaration one now. Declaration or declaratory relief is where you ask for one of two things. A declaration to state the legality of a clause in a contract or a part of a contract, or you ask the court to make a decision on a public law that affects you, whether it's ultra vires or not. And ultra vires means outside of power. That's what declaration does, and it is not a remedy as such in itself, because all they will do is say, yeah, you're right, the Vlad laws are ultra vires. That's all they'll do. They'll just tell you that, and they will not strike the laws down. So you'd have to combine it with something, like, say, for an example, an injunction, which is why they're talking about this. Now, however, it is clear that such declaratory orders will be available instead of and addition to writs of mandamus. And that's from Australian cases. Oh, no, there's some English ones as well, too. Evidence. Affidavit evidence will be necessary to bring to the notice of the court the facts constituting the ground for the application. Looks like you've got to do it within 2 months. And generally what happens when you're using one of these writs is you take in an order nisi, which is the application, and that order nisi, they can do a couple of things with it. The order nisi can be made absolute in the first instance in a very serious case, and that's not just mandamus but prohibition and quo warranto and all of the others. Quo warranto, I didn't tell you about that either. Quo warranto is where you're challenging somebody's authority. So you might be dealing with, say, for example, someone from Veterans Affairs, like I said before, and you think to yourself, well, hang on, this guy might not have any authority, so you've written a letter to him asking him what's his authority. He tells you to get stuff, so you issue a writ of quo warranto to challenge the authority he has to sit in that office. So, what was I telling you about? I forgot now. Oh, okay, yes, the order nisi. You go in, you get it stamped, you'll have an ex parte hearing. Generally, ex parte, I don't think they're going to make the other side come down for the initial. It's possible, but generally they'll hear it ex parte. They'll say, yes, okay, there's grounds for an order nisi. That then functions as a summons, and you go out and you serve the order nisi on the respondent. It can be made absolute, which means you get the writ in one hearing. Ex parte to be done would be very rare. You'd have to have very, very good grounds, and I could see something like that happening, like the Somali lady that was raped up in Nauru, and the scumbags that are pretending to be officers of the Commonwealth, but they're actually just scum. They flew her out of the country by hiring a charter jet for 130 grand. It was a charter jet that they actually have all of the time. Cost 130 grand to fly her out of Australia before her lawyer could get to the court and lodge papers. That is still actionable because that's attempting to defeat the course of justice, which is criminal. That's not a civil deal. But that's when an order nisi may be made absolute in the first instance ex parte, where you could prove to the court that this is something that's in the public interest and it's a necessity right now. It's not that common, but there you go. So the other writs, you've got habeas corpus, which is bring me the body. I think you guys know about that. It's where somebody's detained unlawfully. They haven't been convicted yet. Don't try and put mandamus on someone that's been convicted because it's not going to work. But they are being detained. They either have been refused bail or they're being held without charge or all sorts of stuff. Don't try and put mandamus on someone who's held by ASIO or ASIS or DSD or any of the security agencies, because even if you knew they were detained, it won't lie against the security services a lot of the time. So, that's what habeas corpus is. I mentioned quo warranto, prohibition, and certiorari. We mentioned mandamus. There's no more writs, is there? That's all of the writs, the equity remedies that, our mate Chief Walker Eagle didn't mention. He mentioned injunction, and an injunction is similar to prohibition, but an injunction is generally something, because it's equity, it would generally lie through contract. You can injunct somebody from doing something. An order of specific performance is actually the opposite to an injunction. It's still an equity remedy, and in a contract, someone's refusing to do something that the contract says they have to do, so an order of specific performance can order them to do it. I think a lot of you have heard about liens. It's not lien, it's lien. It's a Norman French word. It came to England with William the Conqueror, as did estoppel and all sorts of other things that are in law now. And a lien is an artificial security interest over somebody's property. That can be intellectual property, real property, physical property, all of it. What else have we got? Order of specific performance, injunction, lien. I mentioned declaration, didn't I? Yes. So those are all of the things that are in Section 75, subsection 5, because that says in which a writ of mandamus or prohibition or an injunction. It does not specifically say in which only a writ of mandamus or prohibition or injunction. So because it mentions two, all of the available, they're calling them prerogative writs. This High Court document says that's not really a good term. They should really call them constitutional writs, because it's in a written constitution here, whereas back in the UK, as you probably know, most of the constitution's not written and they're not in anything like that. Habeas corpus is. That's out of the 1640 Habeas Corpus Act, which, if you actually read that, you'd find also bans forever the court known as Star Chamber. And for fuck's sake, don't get me involved in that because we'll go for another hour. So yes, here a constitutional writ would be a good way of describing it, as this High Court Rules document says. What else did he have to say here? This case, yeah, just remember, kids, you need to prove in the High Court that the government's wrong in the above areas. You know, it's a case of, as I said, I showed you what you need to do. If I'm not mistaken, a cause of action against a Commonwealth official is saved for costs, so you don't need to pay costs. Ah, yes, okay. When I did the habeas corpus, because I messed up, and it was my mistake. I fucked it up because I didn't ask my friend, did you apply for bail? I assumed, and remember people, assume means mother of all fuck-ups. Make an assumption, it's the mother of all fuck-ups. I fucked it up in the Supreme Court, and the Crown Solicitor's Office they applied for an order to costs. They could have got costs because I fucked it up, and what had happened was habeas corpus does not have a requirement for locus standi. You do not need standing for habeas corpus. Anybody, as long as they know what they're doing, can do habeas corpus. The whole idea is to get someone unlawfully detained released. So you can't just go on standing, because what if the guy's an orphan? You know, he could be screwed. Anyway, so I'd gone into the Supreme Court of Queensland in the Brisbane Registry on Thursday afternoon, and because I'm not from Queensland, I didn't know their procedures. I got into a shit fight with the woman that was working in the registry. Turned out she was a JP as well. She tried to bullshit me that I couldn't get a fee waiver, and at that stage I was on the dole and I had a healthcare card. I know better than that. There's a High Court case, and I don't know what the name of it is, so don't ask me, where if you are on any form of government benefits, then the courts are required to waive the fees. They'll argue with you, they'll bullshit you, but they have to do it. The High Court said so. They said something along the lines of no one should be denied justice because of their financial situation, which sounds very similar to Magna Carta, but let's not go there either. So this woman tried to argue with me. I said to her, no, there was a High Court case, and then she said, yes, that's right, it was an appeal from Western Australia, which I thought, well, that fucking sounds about right, because those guys are that far backwards, they're laying on their noses, but, because they've gone all the way around. So, they gave me a fee waiver, and it was about 3:30 in the afternoon. So, luckily for me, the Crown Law Department is only a couple of hundred yards down the road from the Brisbane Registry of the Supreme Court. So we went and served the documents, and they had to get a level 6 or level 7 public servant out, and that's a very, very high level lawyer. And he said, look, normally I would not accept them because you're outside of time for service. Oh, hang on, I've jumped ahead. This woman wanted to give me a hearing on Monday. It's Thursday afternoon, 3:30. She wanted to give me a hearing on Monday. And I said to her, you can't do that. This is habeas corpus. So she made it for 10 o'clock in the morning the next day. So this lawyer, he said, technically you are outside of time for service. You can't serve it now for 10 o'clock here in the morning, but it's habeas corpus, will accept it. So my friend was brought down from a jail, which was 2 hours or something north of Brisbane, and he was there in the morning. I nearly got into a fight with one of the security guards. He tried to push me back from the bar, and I'm like, mate, I'm the fucking plaintiff. Piss off and get your hands off me, you know? I nearly had a fight with a fucking security guard in the Supreme Court. Anyway, That was a funny day, that. What bullshit was I telling you? Ah, yeah, so they accepted that, and because I had fucked it up, they wanted to punish me by going for a cost order. And, the judge said they'd made their application. The judge said, what have you got to say to it? And I just stood up and I said to him, look, Your Honour, if they think they can get it out of me, let them try. And I then thought, well, fuck, I better have a word to this guy. So I said to him, I'm not being facetious. And he said, that, yeah, he knew that. So he said no. He specifically said, Mr. Holford's not in his he's not in his jurisdiction. He's out of his own state and he's on the dole. I don't know what the cost would have been, but there would have been thousands of bucks. So if they find that there's something dodgy, like we saw before, if it's done for an improper purpose, like it's vexatious or something, yeah, an order for costs can be made, even if you're on the dole. But this guy decided not to do it. So it's a case of these things are not as clear cut as our friend. If this Danny Javica, whatever he is, if he was a professional wrestler, I'm pretty sure that we'd have to name him Danny the Showboater Javica, because he likes to showboat and show all of his knowledge, and he doesn't comprehend a lot of this stuff because there's more depth to things than just a couple of one-liners, which he's going to find out very soon when all these people he's given advice to, when they go and fuck things up and they come back and they have a word with him, things might be a little bit different. But in the meantime, let me just review that I've made sure we've covered all of this. And yeah, state law, this is for a Commonwealth law. If you're going to do against the state, you've got to go to Supreme Court. Violates your implied rights to due process? No. It's got to be a specific right that you're owed. It's inconsistent with institutional integrity and independence. I don't know what the fuck that means. I think he must be referring to the cable doctrine I talked before about Chapter 3 courts and cross-vesting. And he doesn't meet any of the other grounds. I don't think he even has a clue what the fuck these writs are for. And it covered the 3 that were named. And I think that's probably about all I will say, with one final word. Any of you guys listening, if you want to know what type of a character this Javica, Chief Walking Eagle is, it's quite simple. Go into Google, type in Danny, Jovica, Google the guy. And you can find out for yourself what sort of character he is. So on that note, I'll leave it to you. You can do what you need to do. I wouldn't be taking his advice literally too much, and I shall see you people around.